see here. Terry Strickland versus Goetz. This party would come up, please. All right. All right, I have it on the calendar for motion for a modification of custody, motion to dissolve the parental rights of the plaintiff, and motion for summary judgment. Any other motions, preliminary motions prior to calling the case?
No, Your Honor.
Goetz, anything prior to calling the case? Motion.
I have a motion for removal of parental rights.
Your parental rights, or? All right. All right. So how does motion break down? Y'all's motion for modification of custody, or?
Your Honor, all the motions were filed by Mr. Goetz. An order was entered, actually a temporary order, back in October 14, 2002. And our position is that it's a violation of law based on neither party petitioning the court for a significant period of time that becomes a final order.
Oh, the earlier order, how long was that in effect?
It's been in effect now for almost 7 years. Now, Mr. Goetz has filed a motion to terminate parental rights. And I don't think the court needs to spend very much time on that because there's really no legal merit to it. There's a procedure or process to terminate an individual's parental rights, and that's set forth in Chapter 7B, and there's just no legal authority at all to address that here today. I don't know if Mr. Goetz has any legal authority at all to support that position, but I would say...
Are you saying in fact, or are you saying...
I'm saying it's a legal matter. I mean, in order to terminate parental rights, you have to file a petition to terminate legal rights. It's got to be verified. It's filed under Chapter 7B in juvenile court. It's not filed in a Chapter 50 proceeding. Aside from the legal aspect of it, it is absolutely meritless with regard to facts. But we could spend a significant amount of time dealing with facts, but as a threshold matter, from a legal standpoint, it's not maintained.
Oh, a motion to terminate under Chapter 50?
He filed it in this proceeding as a motion in this court.
Mr. Goetz, is that correct?
Well, sir, there's a number of things we spoke about I'd like to reply.
Well, I'd like to first of all know if you filed this in juvenile court, or you filed this as part of Chapter 50, which would be in custody.
Being I'm an attorney, I basically filed in response to that hearing.
Well, you're going to be treated as if you are an attorney representing yourself. You understand that, right? Yes, sir.
The fact that it's taken 7 years is not in my control. I moved here with my daughter from Texas 7 years ago. I thought we were going to be married in a family. After I got here, they turned against me and put me out on the street. And I was put
basically almost 7 years now, been fighting to get off the street. I finally got back on my feet. During that time, I've been maintaining a relationship with my daughter. I know I'm not an attorney and there might be mistakes in my case, but what has to be done is what's best for my daughter. And I have solid evidence over a long period of time that her mother has not acted in a condition that is appropriate of a good mother. And I hate to have to do this, but I have to be able to get my daughter her safety and her health in check. As her father, I have both the obligation and responsibility, losing faith in her mother, to have to stand up and do this. I ask the court to recognize her actions and how it has hurt my daughter, and I ask the court to help make sure my daughter is okay.
Well, certainly that's a paramount interest of the court, but under some recent case law, I mean, it'd be very clear that a temporary order entered in October of 2002 would be considered under some recent case law to be a permanent order to require you to show up.
Sir, I had no control. I was living on the street. It was impossible for me to be able to do anything. And now I must do so. Knowing the facts that I do about her mother and the way this has all gone down, my daughter is not safe with her and her family without me there. I'm doing the best I can. I actually overlooked some proceedings in the effort to make sure my daughter is okay.
Well, I'll certainly do that, but I can't overlook procedural problems you have in filing it. First of all, your motion to terminate parental rights.
My effort is only to establish control of my daughter, not take her away from her mother. At this point, for 7 years, I've been kept from her, and it's hurt her. And I've waited patiently for some changes on her mother's behalf and her family. They seem incapable of doing so. I have to establish control to make sure she's okay. And at that point, I'd be happy to make sure that she has her mother and her grandfather around. I'm not trying to keep anybody apart. So as long as she's in control, this is the way it's going to go, I'm sure.
All right, well, your motion to terminate parental rights is denied. Is that what your motion for summary judgment is?
No, Your Honor. Mr. Goetz, on an issue of custody, has filed an unverified, unsupported motion for summary judgment. As Your Honor is aware, a custody determination is very factually specific. It's not the kind of case that is even susceptible of being decided by summary judgment. Even if it were, Mr. Goetz has not supported his application with anything other than a signed motion, no affidavits, no nothing. So we would ask that that motion be denied as well.
Mr. Goetz, you're saying when you file a motion for summary judgment that there is no material issue in the case. There's nothing for the parties to fight about.
So it was my intent to try to solve this problem before I have to prove my case. I do not want to be here to talk bad about my child's mother. I'm trying to make sure she's okay. There were two big issues that were a problem with the current ex parte custody order.
Well, let's don't get into that part. The issue here in a summary judgment motion is whether or not there's an issue of material fact between the parties. When the parties agree on whatever is at issue, then a motion for summary judgment is appropriate. In other words, you owe me $10,000. Yes, I owe you $10,000. I just can't pay it. That would be an appropriate for motion. But here you're saying something about them. They're not agreeing with it.
No, sir. My summary judgment is based on the fact we were not residents here for 6 months. The court order is invalid, and I believe that's a statement of fact. There's nothing to argue about. It's right in their legal paperwork. We were here 2 months before I put out the street.
Your Honor, the parties have lived with this order for almost 7 years. This man has been exercising visitation for almost 7 years. And now here we are on his motion to modify custody. He wants to argue, I guess, that there's no jurisdiction here, which is without merit at all.
The court requires 6 months residency before you have authority. We were not here 6 months. The order is invalid.
And, Your Honor, if you follow that logic to its end, then what will happen is we will simply vacate any orders in the case presently, and then we start back from square one. And that, I would submit, is just not what the law requires.
I agree that a custody arrangement at this point would be best for my daughter, but I cannot deny the fact. This order is invalid.
All right, motion for summary judgment denied. All right, so that leaves us with a motion for modification of custody. Is that your motion?
Yes, sir.
All right.
Ex parte custody order.
Well, at this point, it's a permanent custody order under the law of this state. All right?
It's the only order in place, so that's what you're saying, the ex parte custody order is permanent, and that's what I'm asking to modify.
That's the order of October 2002.
There was an ex parte custody order that became a permanent order. You actually were temporary order back in October of 2002. Your Honor presided over the case then and entered the order. So we don't have an ex parte order any longer. We have a temporary order, which, again, arguably from a legal standpoint, is permanent.
You may put on evidence to change the order, but at this point, it's a permanent order under the law of this state. After 7 years, or just about 7 years, it becomes a permanent order. Okay?
And I asked the court to modify it, take into consideration my evidence for her mother's action, and allow me to have my daughter back.
Right. It's at this point you have to put on evidence. You ready to do that?
Yes.
All right. We'll call your first witness.
Yes, sir. Just like my opening statements, and then go from there.
You got 2 minutes.
Yes.
Your Honor, before we get into his opening statement, on the calendar it's indicated 2 hours and a lot of the case. Is that going to be?
That's correct.
Okay. So each side gets an hour, including cross-examination, goes against each party's respective time.
That's correct. Okay. All right, you got 2 minutes for an opening statement. You may proceed.
This day has been a long day coming for me. I wish I were not here. I wish we did not have to go through this. I have tried every way that I know to make sure that my daughter is okay and to get along with her mother. My name is Michael Lee Goetz Sr. I am the father of Stephanie Ann Goetz. Her mother, Sherry Strickland, and her family invited us here after our child was born. In my mind, as I understood it, to be a family. We were engaged. We came here to be married. Shortly after we arrived here, they turned on me. I was jumped, beaten, and put out on the street, forced to the street. The last time I saw you, you gave me 48 hours to get out of my house. I ended up in a homeless shelter and living on the street. For 7 years, I have struggled to survive. I have maintained my contact with my daughter 3 times a week. Sometimes riding a bicycle 30 miles round trip in all kinds of weather just to spend an hour with you. This situation is absolutely wrong. I've tried everything to get along with no chance of any differences. I come here today not to speak bad about Miss Strickland. She's the mother of my child. I never wanted to be here. But as her father, losing confidence in her ability as a good mother, I have both the obligation and the right to step up here and ask the court to give me my little girl back. I was there when she was born. I cut her vocal cord. I saw her and she saw me. I was the first thing she saw in this world. I took care of her every day until we came here and had her taken from my hands and put out on the street. I am the primary care provider by every definition, except that she made more money than me. It is in the best interest of my daughter for me to maintain control of her life and make sure that she has family, not be destroyed as Ms. Strickland has done. I have brought evidence, and I provided to the court and the attorney on the things that I'm talking about, and it is pretty. I do not want to have to show evidence of this, but I will. I ask the court to modify the custody order and give me my daughter back. As her father, I have obligations that I must do, and with this current situation, if it doesn't change, my daughter's health and future is at stake. That's my opening statement.
All right, thank you, Mr. Goetz. All right, any opening statement?
Yes, Your Honor. Your Honor, Stephanie will be 10 years old in December. This order's been in effect for 7 years. During that time period, Ms. Strickland has been the primary caregiver. This little girl attended Montessori school full-time. This little girl is now attending Aiden Elementary School. The evidence has been made that she's doing very well. She's got extended family here in Pitt County. She's got cousins. She's got aunts, uncles. She's very well-adjusted. She's happy. Since 2002, Ms. Strickland has provided almost all the financial support. The evidence is going to be that up until a child support claim was commenced in, I think, in September of last year, Mr. Goetz had paid a grand total of $520 in child support over that entire 6+ year time period. Mr. Goetz is coming into this courtroom saying that this is my child, and he goes so far as to file a motion to terminate parental rights. Ms. Strickland's done nothing but right by this child. Ms. Strickland's father, who's in his 70s, 3 times every single week over the last 7 years has accommodated Mr. Goetz with this custody order. Now, standing here today, I think Ms. Strickland, of course, will tell you that she feels like a modification would be appropriate. The child is almost 10 years old, and she'll tell you what she thinks is appropriate. But in terms of modifying the custodial arrangement, in terms of who's primary custodian, the evidence is going to be conclusively compelling that no such modification is warranted. And we ask that the court deny Mr. Goetz's motion to modify in the sense that he's trying to change primary custodians. We're not opposed to a modification being made in some respects that will accommodate and take into consideration the child's age and things that have occurred in the last 7 years.
All right, well, both parties' ground rules are that you've got an hour apiece to put on your evidence. That includes questions that you ask the other party, okay? So when you cross-examine the other party, that counts in your hour, okay? We have a number of cases after this, and we keep everybody in line, and we'll proceed as quick as we can. All right? Mr. Goetz, since you're the petitioner, you may proceed to offer any evidence you wish to offer. You have to do that under oath. You have to come up and do that under oath, okay? If you want to bring any papers with you, you certainly do that too, okay? If you'll put your left hand on the Bible and raise your right.
Yes.
All right. You can have a seat right there. All right. For the record, if you'll state your name for the court, please.
I'm Michael E. Goetz Sr.
All right. And you may proceed.
As I said in my opening statement,
First of all, where do you live?
6202 Turnage, Farmville, North Carolina.
How long have you lived there?
About 5.5 years.
All right. You may proceed.
Sorry?
You may proceed.
As I said in my opening statement, the reason I've asked this today is not out of anger to hurt anyone, but it's because I've lost confidence in my child's mother to make wise decisions in regards to my daughter. Over the last 7-8 years, I've collected evidence on the things that have gone on, and it's for those reasons that I had to come here today. Some of the things that have bothered me since I met Miss Strickland, back after she was first pregnant,
Just, we're going beyond the order. The order was entered in October of 2002. If we're going to go back to the dawn of time, we're going to be here a lot longer than 2 hours.
I have 2 statements, short and quick.
Mr. Goetz, you can't be talking about what happened before you all met.
I'm talking about, in relation to my daughter, the things that have happened.
Listen,
Sorry?
listen to me. We have rules here. All
Right.
From the date of the last order, okay, which was October 2002, anything prior to that was presumably covered by that order. So anything you want to say to change the custody or to modify another order has to go from the date of that order up to now. Okay, anything before that presumably was covered in that order, and you're not allowed to go back over that.
My actions since that time are based on these 2 statements I have to make.
And you can't talk about anything that happened before October of 2002.
Yes, sir, I understand that. I'm saying what I'm doing right now is mine.
Don't do that. Now remember, anything you testify to, this is another, just so you won't get frustrated with objections, because they're going to come.
Right.
It has to be things, you can't say anything somebody else told you.
No,
It has to be something you saw, Okay, you got that?
Yes, sir.
Okay, all right, you may proceed.
Difficult to answer under these conditions and this important
Well, these are
information.
conditions which every courtroom in the country is under, so.
I'm here today because Terry Strickland tried to kill our child and abandon it.
Objection.
That is important.
This happened before 2002,
When she was
October.
pregnant and after our child was born, when we were coming here, that's why we came here. Because I couldn't lose my daughter and I was afraid she was going to kill her.
This is before 2002 order?
When we came here at that time, I don't have the exact date, but when we came here, it was about that. That's what I'm trying to explain. I'm not here to try to make problems. I was worried absolutely about the safety of my daughter. And her family has a history of sexual abuse.
Objection.
That is since. That is not before.
My objection was based on prior to the October 02 order. He said they moved here together. They have not reconciled since October of 02, so that by definition would have to precede that.
Mr. Goetz, you have to talk about what happened after 2002.
Since we arrived here, shortly after arriving here, being invited here, I came.
Objection. Again, the order was entered in October of 2002. He's talking about shortly after they arrived, which would have preceded that order.
In 2002, 2002, June 2002. Shortly after that, when all this paperwork is here, referring to that time, shortly after that, she comes home one day, says she doesn't love me. She's taking her child and put me out on the street.
Objection.
This is during this time period, 2002.
No, Lord, I'll set it for background.
I'm just trying to explain why I'm feeling like I am and why I feel like I have to step forward and do something.
That was 7 years ago.
And during that time, after she came home and told me that she didn't love me and that I had to get out on the street and she was taking our child, that while I lived on the street, she made it almost impossible to be able to allow me to see my daughter for the last 7 years. I've had to go through quite a bit, including many occasions, riding a bicycle 3 hours round trip to spend an hour with my daughter. My daughter has not, on the average, been allowed to come to my house except for a few occasions, exceptions like maybe Christmas once or twice. My daughter is not allowed to be able to come to my shop, my PC shop, where up until the time we got here, she used to work with me as a baby. I believe that during this time, the actions of Ms. Strickland.
You say you have a business?
Yes, sir.
What type of business is that?
Mike's PC shop in Farmville, at the computer shop.
What?
PC.
Oh, PC.
Yes, sir.
Computer?
Yes, sir. During the 7 years, I believe that her actions have not been conducive with a good mother. She has destroyed her family. She has made it nearly impossible for her daughter to see her dad. She has kept me from being able to make any decent decisions in my daughter's life. I have not had any opportunity to have say in her life. For instance, she is on medication right now for ADD. I'm not a fan of that, being a substitute school teacher also. I see what kids go through that are on those medications. In the discovery process leading up to today, there were a number of just flat-out wrong things. And I think that they're important to get the facts straight. The fact is, if I may, or to go through these discovery, sir?
You can certainly go through some of what's objected to, and then we'll talk about it.
Right. In the interrogatories, I made an attempt to try to get as much as possible as I could agreed upon before we got here. There are things that, in my mind, shows a consistent pattern of deception. They're not being honest. They're not being straight. It is my opinion.
Objection.
And I have facts for that. There are a number of things, like I wasn't there when my child was born. Didn't cut her umbilical cord. I got videotape evidence of that. That I wasn't jumped by Mr. Strickland and his son. I got videotape evidence of that. These are plainly wrong. And I want to make the fact, these people are not being honest. Ever since I got here, they have twisted and turned and done everything possible to try to keep me away from my daughter. No decent person would keep a good man from being a child's father. Your position is indefensible.
All right, talk to me, not to them.
These are just two of the things in the discovery that are plainly wrong, and I'm willing to submit evidence unless they concede.
About what?
That I wasn't jumped, I wasn't beaten and put out on the street, that I wasn't there and cut the umbilical cord and the first thing my daughter saw, that I wasn't the primary care provider of my daughter all the way up to the moment that we arrived here and they took her from me and put me on the street.
Yes, please listen to me. I'm trying to listen to you, but you're getting off on things that happened when the child was born. We're talking about a modification of a custody order, wanting to change whatever agreement is between the two of you right now. That's what you need to focus on.
Sir, I completely understand your point, but the fact is, at this moment, Miss Strickland's actions are not conducive with a good mother. At this moment, not
Talk
the
about
past.
this moment. You're
Yes, sir.
exactly right. Talk
Yes, sir.
about now.
Yes, sir. I am not allowed to see my daughter except for 3 one-hour visits a week. I am not allowed to make
How
any
many
decisions.
hour visits a week?
According to your court action, I was put on the street and given 3 one-hour visitations a week. I had originally asked for Saturday, Sunday, and Wednesday, but you gave me Saturday, Sunday, and Thursday. During this time, up to now, I have not been allowed to be a part of my daughter, her life. I haven't been able to be a father to my daughter, and those are through Miss Strickland's actions. I have tried everything to get along. It's not happening. I have to step forward and say something, and these other things are part of background. It's important that people realize I'm not here just mad. I'm very concerned about my daughter, and I have major problems with what's been going on ever since my daughter was born. So I would like to know, are we going to be able to agree on some of the facts, or should I present evidence to the fact of repeated bad decisions by Miss Strickland up to this moment about my daughter?
Apparently, you are past the stage of agreement, so yes, you're going to have to present evidence.
All right, well, I would like to just confirm a few things here. According to my interrogatories that I got back from Ms. Strickland, her attorney, I have videotape on my computer that I would like to play.
Well, what?
Being jumped by Mr. Strickland and his son, about being with my daughter at birth and being the first thing she saw and cutting her vote, the things that they are plainly lying about.
Objection to the characterization.
The facts are not accurate, and you know that.
Mr. Gibbs, please listen to me. You remember it's a 2002 order, right?
Sir?
We have a 2002 order.
Right.
That was entered after the child was born.
Yes, sir.
Correct?
Yes, sir.
So the umbilical cord tape would be totally irrelevant, right?
It established
Do you
a fact.
understand that?
I understand your point, but established the fact they're not being honest.
Do you understand why you're here?
Yes, sir. I'm trying to make sure my daughter's okay.
You're asking for a change in the custodial situation, correct?
Yes, sir.
What relevance does whether you cut the umbilical cord of this child have to do as to whether or not there should be a change of custody?
I was the primary care provider to my daughter. I was the one with her every day, taking care of her all the time from the moment she was born. It should be allowed to continue, and it should cause merit whenever you ask who should be taking care of the child. And that there is a repeated pattern of lies in their responses.
Why don't you tell me why you think she's a bad mother and not start before 2002 and start...
In 2002, yes, sir. In 2002, I was jumped and put out in the street and had my daughter taken from me. I lived on the street for 7 years.
Tell me, after 2002, what has changed to want me to change this order that was put in effect in 2002? That's what you should be doing.
Yes, sir. In the last 7 years, my ex has kept my daughter, I believe, from me, except for the court-ordered visitation. She has repeatedly made decisions that are not conducive to a good mother. My daughter...
Tell me how.
Well, taking her father from her is probably a big deal. In fact, it's the biggest deal to me. Unbelievable. After inviting me here and then putting me on the street to die. And then keeping my daughter from me. It's not even a good person, much less a good mother. How can I stand here and not say nothing? And that is the crux of my argument, that it is a repeated pattern of bad decisions that destroyed my family, that goes on today, that will not change unless I step forward and do something about it. And that's why I'm here.
Do you think the custody ought to change to you, or it should be modified to give you more visitation, or what?
I need to be in charge of my daughter. I am Mr. Goetz. My daughter is Stephanie Goetz. We are a family. She has two brothers, Michael Goetz and Justin Goetz. We are a family. Miss Strickland was supposed to be in our family and chose not to. I believe that that decision was probably a mistake. To keep us apart like this, destroy us after inviting me here.
Where's the other children?
They're back west with their mother. I'm divorced. I'm fighting for custody of them, too.
Okay, so you got two children that are elsewhere.
Yes, sir. My oldest son is 27. I mean,
So you got two children elsewhere, and then this child here.
yes, sir. And so I'm asking for legal custody of my daughter. The physical arrangements of her living where she is now, I totally understand. I don't want to rip her out of that. I mean, even though I don't feel comfortable with her being there, in my opinion, having a history of sexual abuse, and me not being able to protect her or being around her is a mistake. But I'm willing to negotiate where she actually lives. But what I need and what my daughter needs is for me to be in control of her life, not shared custody, because it's constant conflict and it'll tear my daughter apart. I'd rather let go. So I come here today to ask for legal custody of my daughter, and I'm willing to negotiate physical custody of my daughter, although I would like to ask the court's clarification that if I am given legal custody, I may ask if I can take my daughter and the Goetz family and go back to Texas. But right now, I'm only asking for legal custody to ensure the safety and health of my daughter after a long, prolonged, documented pattern of bad decisions and conflict between me and her mother.